All right, folks, I'm just waiting for other, okay. We have Ms. Kraus present. So looks like we have all the parties on two of our cases set for hearing this morning. We have Ms. Glazier present on behalf of Glazier versus William Butts, case number 1415211. We have Ms. Dalbenspeck present in the matter of Dalbenspeck versus Butts, case number 2218954. We have Mr. Butts is present. Also, all parties by Zoom. Both of these files were set for a hearing today regarding payment of child support. Ms. Kraus, can you tell me where things are at from friend of the court's perspective and what you're recommending the court do on both these files?
Yeah, if we could start with the one with the party with Valerie first. At the referee hearing on March 20th, the defendant was given the option to make a purge payment of $1,600 or appear today before your honor to address contempt. There has been a non-voluntary payment received this month in the amount of $199.67. MU income withholding collected $85.50 at the end of April, but the friend of the court is not sure if the new employer will meet the support obligation.
I have a question. I didn't get two payments. I only got one payment from William. I didn't get $199. Got 80 some dollars total.
You give me just a minute, I'll verify that amount.
Thank you.
Based on the records that I have, it should have dispersed on 5/2.
Okay. Maybe it's going to be there. It's not. Thank you.
Mm-hmm.
All right, so it sounds like Ms. Glazier has that $199.67. If that was dispersed on the 2nd, it might just be in transit.
Sounds good.
You should be receiving that amount.
Okay.
All right, Mr. Butts,
Yes, sir.
you had your hand raised. Was there something you wanted to say?
I did. I have a paper from the U.S. Department of Treasury where they took $1,129 for my child support on
Oh, wow.
4/24. That might be in there too somewhere because I have the paper right here.
All right, Ms. Kraus, I'm assuming that you haven't seen that yet come through.
We have not. If that's from the IRS, it could tell him that potentially those funds, but there's nothing on hold as of right now.
Okay. All right, and then with regard to Ms. Dalbenspeck's case.
There was a payment, a non-voluntary payment that potentially may not have dispersed of $204.33 the same date, and the income withholding of $87.82 at the end of April. And again, we're unsure if that will meet the support obligation.
Okay, and then with regard to her case, was there a similar referee hearing or?
Yes, it was asked, yes, in regards to addressing contempt.
Okay, so
same date, March 20th.
Gotcha. All right. Okay, so Mr. Butts, I mean, you understand the procedure here. The friend of the court is asking the court to find you in contempt for failing to pay your child support in both of these files. I'm going to go through your rights with you. You do have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. You do have the right to have a hearing as to whether or not you should be found in contempt in either or both of these files. Because in both of these files, it would be a second or subsequent finding of contempt. The maximum penalty that you could face on either or both would be up to 90 days in jail. Do you understand all of those things?
Yes, sir.
Did you want to proceed today on your own? Did you want to request a court-appointed lawyer? How did you want to proceed with regard to the contempt?
I don't need an attorney, Your Honor. That's just more things that I can't afford right now. I'll just proceed with it. I'm hoping I don't go to jail. I just got my job. I go back to work tomorrow because of my arm's busted. I am paying my child support, but I would like to continue to move forward to do what I got to do so I can continue to go forward.
All right, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You understand that you're, again, that you're going to be waiving the right to have a hearing on contempt by admitting to the contempt here today?
Yes, sir.
Okay. And again, you understand that you could face up to 90 days in jail on each of these files?
Yes, sir.
All right. With regard to the file regarding Miss Glazier's case, did you hear what Miss Kraus said regarding your previous hearing before the referee?
Yeah, I owed about $1,600, and at the time that we had court last time, I didn't have a job. Now I have a job. I've been making payments, and I got the paper for my treasury thing for my taxes. I'm trying to do everything. It's slow right now. I just started to get back on my feet. But yes, sir, I did hear.
All right, and do you agree that in that file as to Miss Glazier that you failed to pay the amounts required under the court's order?
Yes, sir.
All right, and the same thing with regard to Miss Dobbins-Beck's file?
Yes, sir.
All right. All right, the court finds that there is a basis for a finding of contempt based on failure to pay pursuant to the court order in both files. And in terms of sentencing, I'd like to hear from Ms. Kraus first, but then also Ms. Glazier and Ms. Dobbins-Beck as to what you both would state regarding sentencing. So Ms. Kraus, is there any recommendation in front of the court?
Yes, in regards to the case with Valerie, the account balance is $23,365.55. Regards to the case with Summer, the balance is $7,713.81. In regards to both cases, friend of the court would ask the defendant to be committed to the Otsego County Jail for 21 days and would request this commitment be held in abeyance and only be served if the defendant fails to pay his monthly support obligation plus monies towards arrears.
All right, thank you. Ms. Glazier, anything that you'd like to say?
Yeah, I agree. Not to put him in jail unless, the later it doesn't happen. But he has a relationship with his daughter now, and I don't want him to be gone for 21 days. It's been a very long time since he's been consistently with her. And that's most important to me. So, William has got a job now, and hopefully he'll keep it. And he's been doing right by Maya. And she's 11 now. So that's all. Thank you.
All right, thank you. Ms. Dobbins-Beck?
I would have to agree with Miss Glazier. Buddy is starting to have a relationship with our son, and I don't see the need for him to go and sit in jail because it's not gonna solve anything with him sitting in jail. It's not gonna help him pay his child support. I don't really care about the child support. I care about him being here and being able to spend time with his son rather than sitting in jail. I don't think it's necessary.
Absolutely.
All right. Based on the statements of friend of the court as well as both the plaintiffs here, I think that's a reasonable recommendation. So the court will adopt the recommendation as stated by Ms. Kraus. So Ms. Kraus, if you'll submit an order for that, and then the court's going to set this for a review hearing in 60 days. Ms. Kraus, if Mr. Butts is complying with the order and you want to have that adjourned out even further, I don't have a problem with that. I'll leave that within your discretion, but I'm going to have it set for 60 days just as a control what's going on. Other than that, Mr. Butts, just make sure that you get in touch with Ms. Kraus so that you understand what you need to do going forward so that you can avoid serving that 21 days, okay?
Yes, sir. Thank you.
All right. Ms. Glazier or Ms. Dobbins-Beck, either of you have any questions?
No, sir. Thank you.
Okay, thank you. All three parties on this case are free to disconnect at this time.
Thank you. I don't know how to leave it.
And then Ms. Cross, I have Mr. Goff connecting right now. Okay, Mr. Goff, if you can unmute, thank you. We're on the record in Brandenburg versus Goff, case number 09-13272. The record should reflect Mr. Goff is connected today by video. This is set for a hearing as to payment of child support. Ms. Kraus, can you tell me where things are at with this file, please?
This hearing was adjourned from April 1st and the bond was to continue, and the defendant was ordered to pay $300 before today. The defendant paid $100 on May 3rd, and he indicated he would not be able to pay the remaining $200. The defendant has a support obligation of $324 and a balance of $16,110.47.
Okay, and what's the recommendation in front of the court going forward today?
The friend of the court would ask the court for direction on how to proceed today.
Okay, so there was a payment on May 3rd, you said?
Correct, of $100.
Okay. Mr. Goff, where are things at? When can you make the rest of that payment?
Probably this month sometime. I'm hoping to come into a paycheck here this month, possibly next month. So that wasn't a paycheck. That was just money that I put on just to try and have something on there until, but I'm hoping to come into a paycheck this month, maybe next month from working with my dad. I could put more on there this month. She asked if I would be able to put the rest of it on there before the court date, before the May 6th court date. And I said that there's no way I could put the rest of it on there before the May 6th court date. Well, I could try and put the rest of it on there this month.
All right, so what the court's going to order, Mr. Goff, is that you do make the rest of that payment. The court's going to set this for a hearing at the beginning of June to monitor whether or not that payment's been made. If it hasn't at that point, the court will consider going forward with contempt proceedings. So okay. It's important that you make arrangements to do that. And Ms. Kraus, if you can prepare an order that reflects that.
Okay.
All right.
Trying to make sure.
Anything further on this case, Ms. Kraus?
No, would it be possible to request that he meets the obligation in full, that at least an additional $24 or something more? Because his obligation is $324 a month.
Okay, then yeah, so a $224 payment.
Okay.
Yeah. All right. Okay, Mr. Goff, that's all for today. If you have any other questions, please contact friend of the court.
Okay.
Thank you.
Thanks.
right, Susie, I've got on my docket a case Foreman versus Kremkow. It's case number 2018102. And it's an objection to a referee's order.
Okay,
It was listed under the show causes, so I'm thinking that's probably why the.
okay. I will come, I'll bring it. Yeah.
Okay, great. I just need to look at that before I bring them in.
Yes, sir. I'll bring it right up.
Okay, thank you.
Your Honor, in regards to the Kremkow case, I am excluded from that case. So if you feel that front of the court would be necessary to be here, I can request that Mr. Brzezinski sign on for that.
Okay, I think we'll be okay.
Okay.
Okay, we have both Mr. and Ms. Crowderfield present today. We'll go on the record in Crowderfield versus Crowderfield, case number 2319399. Both parties are present by Zoom video. We have this set for entry of a final judgment. And I think the last hearing, the issue was Ms. Crowderfield needed to review the proposed judgment and any changes to that. It looks like she did that on May 2nd. So Ms. Crowderfield, are we ready to go forward and finalize things today from your standpoint?
Yes.
Okay, and Mr. Crowderfield, are you ready to proceed as well?
Yeah.
All right, so if I could have both of you raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. I'm going to be asking you both some questions. The questions that I'm going to be asking are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. Mr. Crowderfield, as the filing party in this case, most of these questions will be for you. First of all, Mr. Crowderfield, you signed a complaint for divorce at the time that you filed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In that complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes.
Does that remain true today?
Yes.
All right, and there was one child born of the marriage, is that correct?
Yes.
And under the judgment of divorce, essentially you and Ms. Crowderfield are going to share 50-50 equal custody, both physical and legal custody of your child. Is that correct?
Yes.
Okay. All right. And as the father of your child, do you think that that's in your child's best interest?
Yes, I do.
Okay. And you understand that as part of the divorce, you're not going to receive any alimony or spousal support.
Yes.
You understand that you're going to be waiving that forever and that you could not come back later and ask the court for that.
Yes.
And you and Ms. Crowderfield have already divided up all your assets and debts. Is that correct?
Yes, we have.
All right, thank you. Ms. Crowderfield, have you heard all the questions that I asked Mr. Crowderfield?
Yes.
And did you hear all of his answers?
Yes.
Do you have any reason to believe that any of the answers he gave were untrue?
No.
And do you also agree with the 50-50 custody arrangement regarding your child?
Yes.
And as the mother, do you agree that that is in your child's best interest?
Yes.
Also, you will not be receiving any spousal support or alimony. Do you understand that?
Yes.
And you understand that you would also be waiving that forever and you would not be able to come back later and ask the court for that?
Yes.
And do you agree that you and Mr. Crowderfield have already divided up all of the assets and debts of the marriage?
Yes.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will sign the judgment, so your divorce will be final as of today. Ms. Crowderfield, you're asking to have your last name changed, is that correct?
Yes.
Okay, so that means that from today forward, your last name will be legally changed. So it's important for you to change your identification and other documents, okay?
Okay.
Also, a copy of the judgment would be available for the both of you if you need a copy of that for your records. And Ms. Crowderfield, you will probably need that to change your name, okay?
Okay.
Mr. Crowderfield, do you have any questions at all?
I do not.
Ms. Crowderfield, do you have any questions?
No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Your Honor,
Yes.
do you have the file with Brandon Fennell, 2018-17445-DS?
Oh, I did have that on the docket. So let's call that case. And that's Fultz versus Fennell, is that correct?
Correct.
So that was set for hearing at 9 a.m. It's now 9:25. Mr. Fennell has not appeared either in person here in the courtroom or on Zoom. And neither has Ms. Fultz, but more specifically, Mr. Fennell hasn't appeared. How do you want to proceed in light of that?
For on the record, so on April 1st, the defendant did fail to appear and the court had verbally issued a bench warrant. However, the process was to stop to allow proper notice because friend of the court discovered that the defendant's address was not updated in our system. The last payment was received on the case was $300, which was the bond payment in April. Previous to that, there was a non-voluntary payment of $4,015 received in March of 2023. His obligation is $103, and he does have a balance of $1,686.71. Friend of the court would request a bench warrant in the amount of $500 plus $100 in court costs.
Okay, based on Mr. Fennell's failure to appear today as ordered, the court will sign that bench warrant once it's presented, and we'll go forward with Mr. Fennell's case once he's arrested and brought before the court.
Thank you.
Thank you. Okay, Ms. Foreman, are you able to hear me?
Yes, I am.
Thank you. And Mr. Kremkow, I need you to unmute and turn on your camera. Can you hear me, Mr. Kremkow?
Yes, I can hear you.
Okay, great. We're on the record in Foreman versus Kremkow. This is case number 2018102. The record should reflect both parties are present today by Zoom video. And this is set for a scheduling hearing. Mr. Kremkow, you have filed an objection to a friend of the court's recommended order regarding child support. Is that correct?
That is correct, yes.
Okay, so the court's going to set this for an evidentiary hearing. Mr. Kremko, as the party objecting to the recommended order, you would need to bring any documentation. You know, I'm looking at your objection, and that based on the basis of your objection, you would need to bring whatever documentation you have as to income, because the court's main job here in terms of reviewing this is going to be to determine whether or not friend of the court has imputed the proper amount of income to yourself and to Ms. Foreman for purposes of the calculation. So to the extent that you're disagreeing with the calculation, any documentation that you have to substantiate that you should bring with you. And then the court will also take testimony from both parties at that hearing. And then I'll make findings with regard to what income each of you has. And then that may or may not change that recommendation based on application of those numbers to the formula. So Mr. Kremko, do you have any questions about what you need to do for that next hearing?
No, sir.
Okay, and I'm going to set this for 2 hours. Mr. Kremko, do you think that would be enough time for you to present to the court whatever evidence you need to present regarding income?
Yeah.
Okay. All right, and Ms. Foreman, do you have any questions about the process and how we're going to go forward?
No, I don't.
Okay, so that will be an in-person hearing. The court is required, because I'll be taking evidence and testimony, the court is required by court rule to have that hearing in person. So I just want to let you both know about that ahead of time. The court is going to send you a notice of the date and time of that hearing. And again, just bring whatever documentation you have, and then the court will take testimony. So look for the that notice of the hearing in the mail. The court will set it for a 2-hour hearing. That's all I have for today. Ms. Foreman, do you have any questions at all?
No, sir.
Mr. Kremkow, do you have any questions?
No.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
Thank you.
Thank you.
Okay, if I could have you guys unmute, please.
I think we are now.
Yep, thank you. All right, are you Tanya and Steve Allmacher?
Yes.
Yes.
Okay, we're on the record in Allmacher versus Allmacher. This is case number 2419629. The record should reflect both parties are present today by Zoom video. This is set for a status conference in this case today. And so, let's see. It looks like you guys have a hearing set before the friend of the court regarding custody, parenting time, and child support issues on June 26th. So the purpose of this hearing today is to determine whether or not the two of you have been able to reach any agreements regarding the assets and debts of the marriage, dividing up any property or any debts that you have. Ms. Allmacher, as the filing party, have you been able to reach any agreements? Is there a disagreement as to any of those issues?
No, not really. I mean, we haven't, I guess we don't even really know how to go about doing that, like maybe a mediation or something, because we're pretty much in agreement with everything.
Okay. Mr. Allmacher, do you agree with that?
Yes, I do.
All right, so what I'm going to do then is we have a service called community mediation. That's where the two of you would They do it by Zoom, just like we're doing today. The two of you meet with a neutral third party to help you kind of divide up any assets or debts and reach agreements as to that. So I'm going to refer it to them. They will be in contact with both of you to set up a date that works for your schedules. And then the court will set this for a final hearing date. Let's see. So your case was filed in March. As you both may be aware, there's a 6-month waiting period where there's minor children involved. So the court will set this for final hearing right at that 6-month expiration period. If you've been able to reach agreements as to all issues, which it sounds like you probably will be able to, then we can finalize the divorce at that time. If there are any issues, then we can address those at that time as well. Ms. Allmacher, do you have any questions about that process?
No.
Okay, Mr. Allmacher, do you?
No, I do not.
Okay, Ms. Kraus, was there something that you needed to add to this?
Yes, there was a hearing with referee legal on 5/1 and both parties failed to appear.
Okay, are you guys aware of this next hearing date on June 26th?
Yes, we are. We both forgot about the
May 1st.
meeting.
Okay, so it's very important that you attend that hearing on June 26th so that your case isn't delayed. And also, I mean, you know, the court schedules these. When you don't show up, it puts other parties at a disadvantage because you're taking up time that could be used for other people. So
Right.
we need to make sure that you appear for that June 26th hearing, okay?
Okay.
And then again, the court will send you notice of a final hearing, and that's probably going to be in September based on the timing of your case. And if neither of you have any other questions, that's all I have for today. Again, just make sure that you attend that hearing on June 26th.
Okay. Will we receive something in the mail to go through the mediation or phone?
Yeah, the community mediation will contact you, so just make sure you follow up with them when they do that.
Okay.
Okay. All right, thanks. You're both free to disconnect at this time.
Okay, thank you.
Okay, if I could have you both unmute, please. Thank you. All right, we're on the record in Pfeiffer versus Walsh. This is case number 2219029. The record should reflect that both the plaintiff, Ms. Pfeiffer, and the defendant, Mr. Walsh, are connected today by Zoom video. And Ms. Pfeiffer, I believe this motion was filed by you, and you're asking the court to order a revocation of the acknowledgement of Mr. Walsh's parentage here and to terminate the child support based on that. Is that correct?
Mr. Walsh asked me to file for this because he does not want to pay child support anymore, and he wants his name, I guess, taken away from her. I don't know how to put that into terms.
All right, Mr. Walsh, do you believe that you are not the biological father of the child in this case?
Well, Maya told me, told me I'm not the father, and has been telling Caroline recently that I'm not the father. So that's why, like, they treat me different. So I figured out since that's the case, I'll get the blood work done and find out. So that way I don't keep getting put in a hole.
You knew you were the father the day you signed her birth certificate, Sean.
All right,
You weren't
this
her
is
dad.
Miss Piper, this isn't the time to argue about what is or is not, hasn't happened in the past. So this is a very straightforward proceeding. The court's gonna order the genetic testing so that I find under the statute that there's sufficient cause to order genetic testing in this case. And that'll solve all of our problems because that'll tell us one way or the other for sure, whether or not Mr. Walsh is the father. So
He's
the court's
not.
gonna sign that order. And so Mr. Walsh, the court's gonna provide 90 days for you to get that testing done. And Ms. Kraus, I don't have this come up a whole lot. Do we have information for him about where he can go to get this testing done?
He could contact the office. We do have some information that's usually with the ROPA packet. But
Okay.
he would definitely be able to do that. And I believe that this proceeding could be set in front of the referee as well.
Okay, so Mr. Walsh, the court's gonna allow 90 days, like I said, for you to get the genetic testing done. You should contact the friend of the court office in Gaylord and they can help you get information so that you know where to go to get that taken care of, okay?
Okay.
And then the court will refer this for a hearing before the referee in about 90 days. And Ms. Kraus, I'll sign that order that was provided here in the file. So I'll sign the order that's in the file.
Okay.
Okay.
All right, Mr. Walsh, do you have any questions?
No, sir.
Ms. Pfeiffer, do you have any questions?
Yes, moving forward, can he file all his own paperwork?
Yeah, I have no idea why you didn't have to file this.
Well, not the time or the place, like you said, but I was forced into filing the paperwork.
Okay, well, you don't have to file anything as far as I'm concerned, unless you're asking the court to do something for you, then you have to file your own stuff.
Well, thank you. I appreciate that answer.
Okay. All right, that's all for today and both sides are free to disconnect at this time.
Thank you.
Thank you.
All right, our next hearing set for 9:45. I don't see those parties present yet, so we'll just take a short break. All right, ma'am, are you Alexandria Davis?
Yes, I am.
Okay. All right, we've got Mr. Rolla connected. We'll go on the record. This is Davis versus McDonald, case number 2319451. And we have the petitioner here, Ms. Davis, present by Zoom video. And we have Mr. Rolla here on behalf of the state, also by Zoom video. This hearing was set for 9:45. It's now 9:50. Mr. McDonald has not appeared. This is the date and time set for entry of a consent judgment affiliation. Mr. Rolla, anything for the record on behalf of the state?
Yeah, sure. Thank you. For the record, Michael, on behalf of the people, the court should have a answer. I believe that was signed originally by the defendant. And
Yeah.
as the court's well aware, if he does that and then he fails to respond, the court can treat his signed document as an acknowledgement for the purposes of this, having this judgment entered, especially since if you take some testimony from the other party.
Okay, thank you. So Ms. Davis, the purpose of this hearing today is to establish Mr. McDonald as the father and to provide a basis for Mr. McDonald to then pay child support. Do you understand why you're before the court here today?
Yes, Your Honor.
Okay. And you are the mother of Araya and River, is that correct?
Aria and River. Yes, Your Honor.
Okay, Aria, thank you.
And Judge,
All
there's
right.
no support on this one. There's not a support
I'm sorry.
order.
Oh,
There's
there
not a
isn't.
support
Okay,
order.
got it. Okay, thank you. All right, so Ms. Davis, you understand that this order would establish Mr. McDonald as the father of those children?
Yes, Your Honor.
And do you have any objection to the court entering that order today?
No, Your Honor.
Do you believe that he is the father of those two children?
Yes, Your Honor.
Okay. All right. Based on Mr. McDonald's failure to appear and Ms. Davis's statements for the record here today, the court finds it would be appropriate to enter that order establishing affiliation. So the court signing that. Mr. Rolla, anything else that we need to address for the record today?
No, Your Honor, we just advised that once it returns to our office, we'll make sure copies are sent out of the order to the parties.
Thank you. Ms. Davis, do you have any questions at all?
No, sir. Thank you.
Okay, thank you. That's all for this hearing, and all parties are free to disconnect at this time.
Thank you.
Thank you, sir.
Okay, our next hearing is set for 10:15. The court will be in recess until that time. Okay, if I could have you both on mute, please. We'll go on the record. This is Weber versus Weber. Case number 2319475. The record should reflect both parties are present today by Zoom video. This was set for a final hearing today. It looks like the last time we met was last month in April. And the parties were to submit the final judgment so that we could finalize things here today. And I don't see that in the file. So Mr. Weber, is there some issues that have come up over the last month?
No, it's just been busy, and it honestly just slipped my mind. I've been super busy. That's why I have no excuse.
All right, Ms. Weber, from your standpoint, are you ready to proceed once that judgment is submitted?
Yes.
Okay. All right. So, Mr. Weber, I'll set this for one more hearing. You know, I'm not going to just keep setting dates if we're not ready to go forward. So, if you don't submit that judgment by the next time, the court may dismiss the case for lack of progress. Okay.
Yes, sir. I will not let that happen.
All right. Very good. Do you have any questions at all, Mr. Weber?
No, I do not.
Okay. Ms. Weber, do you have any questions?
No, I do not, sir.
Okay. Thank you. That's all for today. And you're both free to disconnect at this time.
Thank you, Your Honor.
Hello?
All right, Mr. Rinkevich, are you able to hear me okay?
Yeah, I stepped outside of work. Sorry.
Okay.
I'm gonna stop moving
We're on
until I get a secluded area.
Okay. We're on the record in Rinkevich versus Rinkevich. This is case number 2319259. The record should reflect that the plaintiff, Mr. Rinkevich, is present here today by Zoom. The hearing was set for 10:15. It's now 10:20. Mr. Rinkevich is not present. I have this set for entry of a final judgment of divorce here today. Mr. Rinkevich, is that how you wanted to proceed?
There's a couple things we didn't go over with mediation, which is kind of weird. So when we were married, we got a dog, and that wasn't brought up at all. And also, like with taxes, that none of that was brought up. Also, like it was kind of a really rushed process, I believe. But we did agree on a couple things. But there's a couple things that is like the dog and taxes that weren't agreed upon. That was the only issue I have right now.
All right. Do you have any idea why Ms. Rinkevich isn't present today? Have you been in contact with her?
Yep, she told me there was court today, and obviously she doesn't care too much about court. And I do apologize about last time not being there. My boy had influenza, and we were downstate. And it just totally missed my mind. I'm sorry.
All right. Do you know how you want to proceed with regard to the dog and with regard to taxes?
I think it should be every other year for taxes. I'm sorry about the vehicles. It should be every year for taxes, where I'm able to claim them, and she's able to claim the odd year. And then the dog, I would say wherever Kai is, the dog goes with.
Whatever is what on that last one?
Wherever the son is at, our son, the dog should be also with his son. To make it simple.
All right, so here's the thing. So Ms. Renkevich, I think this is the third hearing that she's failed to appear at. So from my standpoint, she's in default. If she's not going to appear for the hearings, that's not a reason for me to not finalize things today. And because she's not appearing for these hearings, she kind of loses the ability to contest going forward. So if you want to finalize things here, I have a judgment from last November that you guys submitted.
The first one that we agreed on, that's already been
Right.
signed off. I'll take that all
Yeah.
day long.
All right. So, you know, this case has been out there for a long time. I'm not going to keep setting hearings just for Ms. Renkevich to not appear. And like I said, this is the third time based on my records that she's failed to appear. So the court is going to incorporate in that judgment the mediation agreement that you guys did reach. And then the court is going to include in that judgment that you will alternate years claiming the child on your taxes. Is that what you mean by that?
Yes. So every other year I get taxes, and wherever their son is at, the dog will be with.
All right.
And we're going off the old documentation or the new mediation. I just want to get that clarified. Because I personally think we should go off the original one that we already kind of finalized everything. And then she said, no, I don't want to do that. Then we did mediation. But if she doesn't want to show up to court, then I think we should go off the original one that way. Just says pretty much, I get the house, she gets the car.
Well, we have to follow the mediation agreement because that's a signed agreement that you guys entered into.
Okay.
So
that's fine, but the dog and the taxes though, we're putting that also there. So I get taxes every other year, and then the dog goes wherever Kai's at, right?
Right, because those are things that you guys did not agree on, and again, she's not here today, so she loses the ability to contest that.
Okay, sweet. Sounds good to me,
All right.
sir.
Okay, so can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Renkevich, I'm going to go through some questions with you. These are the questions I'm required to ask to establish the grounds for divorce under Michigan law. So first of all, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes, sir.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In that complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that
Correct.
true when you signed the complaint?
Yes, sir. Yes, sir.
Does that remain true today?
Yes, sir.
And you have one child that was born of the marriage, is that correct?
Yes, sir.
And under the judgment of divorce, essentially you guys are going to share joint legal and physical custody with the equal number of overnights for each parent, is that correct?
Yes, sir.
And as we indicated here for the record, the two of you will alternate claiming your child on your taxes every other year.
Yes, sir.
And then with regard to the pet, unless otherwise agreed, the pet will be with whatever parent that your child is with.
Yes, sir.
And then the court's going to incorporate and attach to the judgment of divorce the mediation agreement that was reached by the two of you.
Correct.
All right. And under the agreement, you will not be receiving any alimony or spousal support. Is that correct?
Yes, sir.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yeah, that's perfectly fine.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of Mr. Renkevich. Again, based on Ms. Renkevich's multiple failures to appear, the court finds that she is in default. The court has reviewed the judgment and the mediation agreement. I find that it's generally equitable. And so the court will sign that. Mr. Renkevich, if you need a copy of that for your records, you can get that here at the clerk's office at the courthouse in Gaylord, okay?
Okay, thank you so much, sir.
But as of now, I'm signing the judgment, so your divorce is final as of today, okay?
Sweet, thank you.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
You have a great day. Thank you.
Okay, we're on the record in Totten versus Totten. This is case number 2319468. That was set for hearing at 10:30. It's now 10:37. Neither party has appeared. The court notes that neither party appeared for a hearing in this court back on April 1st, and that neither party appeared for a hearing before the friend of the court on April 10th. So for those reasons, the court is going to dismiss this action for failure of either side to proceed with their case.
you want me to wait until, to let people in for right now?
Yeah, I've got a couple more.
Okay.
Zooms before. Thank you.
Yes, sir.
All right, Ms. Piper, are you able to hear me okay?
Yes, I am. Thank you.
And we have Mr. Scoopin connecting here. You can just hold on for a minute, Ms. Piper. It looks like you might be having some trouble connecting it. Looks like you just got kicked out, so.
No problem.
I'm not sure what the problem is. He's signed in here, but camera and microphone are not turned on. Maybe just while we're waiting, I mean, Miss Piper, I thought that this case had settled, or are we waiting for closing docs, or can you kind of just tell me where things are at?
Yes, so it did settle, and the plaintiff just filed a motion for approval of the settlement because it involves a minor. And I believe that's up for hearing June 4th at 3:15. And that was just filed on Friday by the plaintiff, so.
Okay, all right. So I think I'm just gonna, adjourn this out then until that date. If you wouldn't mind just giving Mr. Scoopin a call.
No problem.
And letting him know that, we didn't really take care of anything here today. Oh, there he is. Okay.
I'm so sorry. If I told you what just happened, you would just laugh at me. There's a little box that I had to check to say I understand this is being recorded before I could click on. Oh, so funny. Yes, well, I could hear you, Your Honor, and what Kalen said is absolutely correct.
Okay, great. Was there anything that you wanted or needed to add to that?
No, sir.
Okay, great. So we'll just plan on going forward then in June and closing things out, and you're both free to disconnect. Thank you.
Thank you.
See you, Kalen.
Yes, see ya.
Okay, the next case is Boer versus Boer, case number 2319356. That was set for hearing at 10:45. Neither party has appeared. It's now 10:53. Looking at the file and consulting with Jennifer, it sounds like there may have been a mix-up. That time and date has been changed a couple times. So the court's simply going to reset that for another status conference next month. Okay, Mr. Blumberg, do you have your client there with you?
I do.
Okay, great. We're on the record in 4 versus 4. I did make a previous record. I didn't know if you guys had the time mixed up. So for the record, disregard the court's prior rescheduling of this for next month. And we do have Mr. Blumberg here present by Zoom on behalf of his client who's with him. We have Mr. Bohr present by Zoom video as well. And this was set for a status conference today. Mr. Blumberg, from your side, can you tell me where things are at?
Sure, Judge. The parties, I think, have come to an agreement. We're working out the details of that agreement. I have drafted a settlement agreement that needs to be revised based on our most recent discussions. But I think I can represent to the court that the parties have reached an agreement on all of the issues and that a judgment of divorce will be prepared, and hopefully we can get it entered at your next motion day.
Okay, thank you. Mr. Bohr, is that correct from your standpoint?
I just received the draft settlement about 20 minutes prior to this meeting, and there was some confusing verbiage in there, some things we haven't discussed. So at this point, I'm not sure. We probably should have went through with the mediation.
All right.
Canceled.
Okay, well, what I'm going to do then is set this for a status conference or a final hearing in June. If both sides are able to work out whatever changes need to be made to the proposals, by then we can enter the judgment of divorce. And if not, then I think we'll have an idea of where the issues are and we can address that going forward. Mr. Bohr, do you have any objection to that?
No, that's fine.
Okay, Mr. Blumberg, any objection to that?
No, Judge. Again, I think we're going to be able to resolve whatever issues remain.
Okay. All right, I will put that in order. We'll send out the notice of date and time for that next hearing, and all parties in this case are free to disconnect.
Thank you.
Thanks, Your Honor.
Okay, Mr. Baker and Miss Baker, if I could have you both unmute, please. Here we go.
Okay.
We're on the record in Baker versus Baker. This is case number 2419570. The record should reflect that both parties are present today by Zoom video. I have this set for a final hearing to enter a judgment of divorce. And Mr. Baker, is that how you wanted to proceed today?
Yes, Your Honor.
Okay, and Ms. Baker, is that how you wanted to proceed as well?
Yes, sir.
Okay, so I'm going to place you both under oath, and then I've got some questions that I need to ask each of you. The questions that I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you both would please raise your right hands. You both solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I do. Yes.
Thank you. Thank you. You can lower your hands. Mr. Baker, you filed the complaint for divorce in this case and you signed that complaint. Is that true?
Yes, sir.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
Had you been a resident of Otsego County for at least 10 days?
Yes, sir.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
And under the proposed judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, I don't want nothing from her.
Okay. And the judgment indicates that you're going to each be responsible for whatever debts are in your own names and that you've already divided up any property between the two of you. Is that correct?
Yes, sir.
And you don't own any real estate or real property together. Is that correct?
No, right.
Okay. Ms. Baker, have you heard all the questions that I asked Mr. Baker?
Yes, sir, I did.
And did you hear all of his answers?
Yes, sir, I did.
Do you have any reason to believe that any of the answers that he gave were untrue?
No, sir, everything is correct.
All right, Mr. Baker, can you keep the camera on you? I don't know who that other individual is, but this is a court proceeding.
Yep. I'm sorry.
That's not appropriate.
No, you're fine. You're fine. I'm sorry.
All right. Ms. Baker, are you currently pregnant?
No. No, sir.
All right. And do you agree that you've already divided up all the property between yourself and Mr. Baker and that you don't own any real estate together?
Right, everything's been divided and we don't own anything together.
All right, very good. The court finds that the statute, oh, I'm sorry, Ms. Baker, you also are not going to be receiving any spousal support or alimony. Do you understand that?
Yes, sir.
And you understand that you would be waiving that forever and you would not be able to come back later and ask support for that?
Right, I understand that.
And Ms. Baker, you understand, you're asking to have your last name changed to White, is that correct?
Yes, sir.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I've signed that proposed judgment, so your divorce is final as of today. Ms. Baker, that means that your name is legally changed, so you need to make sure that you change your identification and other documents. If either of you would like, if either of you would like a copy of the judgment for your records, you can get that at the courthouse here in Gaylord. Ms. Baker, do you have any questions?
No, sir, thank you.
Mr. Baker, do you have any questions?
No, Your Honor. Thank you.
Thank you. That's all for today, and both parties are free to disconnect at this time.
Thank you.
What's wrong with him?
He had a couple strong Coca-Colas this morning.
He was strong?
Mr. Trush, are you signing in on Miss Ford's case in Crawford County?
Yes.
Okay. And do you know whether you're signing on for the FOC arraignment here as well?
I have not been given any information about that, so I'm assuming no, but I mean, if the court needs someone, I can be here.
We're going to do them back to back, so if you don't mind just remaining connected, I would appreciate that. Thank you. Okay, Miss Ford, are you Carrie Ford?
Yes, I am, Your Honor.
Okay, it's just going to be 1 minute. Mr. McFelda to sign in, so if everybody can just remain on the line here.
Judge, Mr. McFelda is not here today. Mr. Haven will be appearing.
Oh, okay, perfect. Thank you.
Yep. Judge, Mr. Haven will be joining us here shortly. I just messaged him.
Okay, thanks. I know we're a little early. Okay, we've got everybody connected, so we'll go on the record. This is in the matter of People versus Carrie Ford, Crawford County case number 225139. The record should reflect Ms. Ford is present today by video from the Crawford County Jail. Hearing on her behalf for purposes of arraignment today is Mr. Trush, and then we have Mr. Haven here on behalf of probation. And Ms. Ford, you're before the court today for arraignment on an alleged probation violation. It alleges that you violated condition 3 of your probation in that you failed to report to your supervising agent on or about November 1st of 2023 or any time after that. Do you understand why you're before the court today?
I do, Your Honor.
And I need to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford a lawyer, one would be appointed for you at public expense. Mr. Trush is here today to represent you for purposes of arraignment on this probation violation. If you are found guilty of the alleged violation, because it is a non-technical violation, it could subject you to the maximum possible penalty on your underlying charge, which is this 10 years, Mr. Haven? And you're muted, Mr. Haven.
Actually, Your Honor, I think it will be a 5-year.
Yes, that,
It's a
because it's an attempt, possession of meth.
Okay.
So,
All right, I didn't see the attempt. Okay. All right, thank you. So Ms. Ford, do you understand all those things I've just stated to you?
Yes, Your Honor.
All right, Mr. Trush, have you had a chance to speak with Ms. Ford today?
I did, Your Honor. In addition to being the duty attorney on this, I was the attorney on the underlying file and still represent Ms. Ford in an ongoing NA case. I did discuss this with her, and we'd be prepared to admit the violation today.
Okay, Ms. Ford, is that correct?
Yes, Your Honor.
Do you need any more time to speak with Mr. Trush before we go forward in that way?
No, I don't, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. You can lower your hand. Ms. Ford, you understand that by pleading guilty to the alleged violation, you're going to be giving up the right to have a hearing?
Yes.
Okay, and then as we indicated, it could subject you to the maximum possible penalty on your underlying charge, which is up to 5 years. Understand that as well.
Yes, I do.
With those things in mind, what is your plea to that probation violation today?
I plead guilty, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything?
No.
Is it your own free choice to enter this plea?
Yes.
And are you pleading guilty because you did violate your probation?
Yes, Your Honor.
So Ms. Ford, on or about November 1st of 2023, were you on probation in Crawford County?
Yes.
And were you aware that part of the conditions of your probation was that you were to report to your agent as ordered?
Yes.
And did you fail to do that?
Yes, I did, Your Honor.
All right, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that Ms. Ford did violate her probation as alleged. The court will accept the guilty plea. Mr. Haven, did you want to have this set out for a sentencing hearing and do a updated PSI?
Your Honor, I think that would be appropriate. This is Agent McFalda's case, and I did not have a chance to discuss with him what he would like to do. He is off for a couple of days, so probably setting it out for sentencing would be appropriate.
Okay, so Ms. Ford, the court's going to set this for a sentencing hearing at the court's next available date. And Mr. Trush, has Ms. Ford been screened? I mean, is she going to qualify to have you appointed to this case to represent her going forward?
Yes, Your Honor. I'm familiar with her situation. She is going to qualify for counsel. So yes, I will be appointed.
Okay, thank you. Mr. Haven or Ms. Koch, anything further that we need to address from the people's side today?
No, thank you, Your Honor.
No, Your Honor.
Mr. Trush?
And nothing further.
Ms. Ford, did you have any questions at all?
No, I don't think so, Your Honor. Thank you.
Okay, thank you. That's all for today. And all parties on this case are free to disconnect at this time.
Thank you, Your Honor. Thank you.
Okay, sir, are you Nathan Canuck, or how do you spell your or pronounce your last name?
Noak.
Noak. Okay, you're Nathan Noak, is that correct?
That's correct.
All right, we're on the record in Young versus Noak. This is case number 0712472. The record should reflect Mr. Noak is appearing today by video from Otsego County Jail. We do have Ms. Kraus here present on behalf of the friend of the court. We have Mr. Trush here for purposes of arraignment. And Mr. Noak, you're before the court here today for arraignment on a bench warrant that alleges that you failed to appear for a hearing in this court back on October 5th of 2020. And that hearing was for the purposes of enforcing a child support order. Do you understand why you're before the court?
Yes, sir.
All right. You do have the right to, I'm going to go through a few things with you with regard to your rights. You do have the right to have a hearing as to whether or not you should be found in contempt for failing to appear, as well as found in contempt for failing to pay child support as ordered. If you are found guilty of contempt for failing to appear, the maximum penalty that you could face would be up to 90 days in jail and or a $1,000 fine. As to the child support matter, Ms. Kraus, do you know whether this would be a first finding of contempt or a second or subsequent?
I am not for sure.
Okay, so Mr. Kraus, Mr. Noak, the maximum penalty you could face if you've already been convicted of contempt for failing to pay child support once would be 90 days. If this was your first finding, the maximum penalty you could face would be 45 days. Do you understand those things that I've stated to you?
Yes, sir.
You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense because this does involve the potential for incarceration. Do you understand that?
Yes, sir.
All right. Before we go further, Ms. Kraus, what is the position with regard to friend of the court here today in terms of going forward? Are you asking the court to proceed with contempt sanctions?
No, the defendant does have a support obligation of $254. After this month, the case would be in arrears only, as charging is set to stop. The total balance owed is $22,804.59. Friend of the court would ask that the defendant be released on a PR bond with the condition that he appear on June 24th before the referee for contempt screening and to monitor payments made or received, because we did receive information that he is currently employed.
Okay, Mr. Noak, were you able to hear that?
Yes, sir.
Do you have any objection to proceeding that way?
I do not. I am afraid I'm going to lose my job.
Okay. Well, based on what Ms. Kraus is saying, we would release you here today under a PR bond, and then, but you would be required to appear for the friend of the court in June. Do you understand that?
Yes, I do.
Okay. Are you willing to abide by that as part of the conditions of your PR bond?
Absolutely.
All right. Okay, so I think that's, given the status of this case, I think that's a reasonable way to proceed. So Ms. Kraus, if you can send that paperwork over, the court will sign that. So Mr. Noak, you will be released today. If you have any questions about that date in June or otherwise, I would encourage you to contact the friend of the court office, okay?
Okay.
All right. That's all for this hearing today. The court will enter not guilty pleas on behalf of Mr. Noak with regard to both contempt charges. Mr. Trush, thanks for being here. I appreciate your time. All parties on this file are free to disconnect at this time.
Your Honor, one quick question.
Sure.
Did you guys get anything? He's got a failed to appear on a 2020 PPO case as well. Did you get anything on that or no?
I did not, no.
Okay, I'll do some checking and see. It might have been Judge Hunter, or I'll check with the prosecutor on that as well.
Okay, sounds good. Let us know.
Okay, thank you, sir.
Great. Next hearing in the morning is at 11:45. So
All right.
take a break until then.